All right, Saturday, a federal judge just heard a secret audio tape played inside a sealed courtroom. And according to court documents filed this past Thursday, what came out of those speakers didn't just surprise the room. It changed the legal picture entirely. 47 seconds of audio recorded 5 years ago. That's all it took to shift the entire weight of a federal obstruction case in a single afternoon. You saw the headlines this morning. Here's what every single one of them missed. Quick context. The subject, a recorded private conversation that federal prosecutors had been fighting for over 2 years to surface in court. The issue, whether a secretly made audio recording captured during a private meeting at a New Jersey estate in July 2021 constitutes direct evidence of obstruction, consciousness of guilt, and the deliberate mishandling of classified national security material after leaving federal office. Timeline, fast version. Weeks before the recording was ever made, classified files were flagged missing from federal archives. 8 specific document numbers, each one formally requested for return in a certified written notice. Days after that request was delivered, a private meeting took place at a private property, not logged on any official schedule, not flagged, not disclosed to federal record keepers. Shortly after that meeting, boxes were moved between locations. Legal teams were quietly notified. Public denials began. That's the setup. Now the documents. Okay, the evidence. First document, filed Thursday in Federal District Court in Washington. I pulled page 31. According to the official transcript included in the filing, the recording captures a voice positively identified by 3 separate forensic audio analysts across 2 independent labs discussing a specific military planning document. That document is described in the filing as, quoting directly here, not declassified, not authorized for this setting, and not something that should have been removed from federal custody. That's not my take or my interpretation. That's the government's filing, verbatim. What it means in plain English, the speaker acknowledged on tape, in their own words, that the document sitting in that private room had 0 legal business being there. But here's the part that actually got my attention. Page 58, completely different section of the same filing. The government describes a second voice captured on the recording, an unidentified individual asking a direct question about the document's current classification status, and the response, captured word for word in the court record, confirmation that the document was still classified. Still, present tense, after leaving office. No declassification order on file, no legal authorization for removal. Put those 2 moments together. Yeah, that is a serious federal legal problem. I read through this filing 3 separate times before writing this. The pattern is unmistakable once you see it. The recording was made without the full knowledge of at least one other person present in the room that day. The specific document referenced on that tape had been formally requested for return by the National Archives 7 weeks before this meeting ever took place. The conversation captured on tape directly contradicts sworn written statements submitted by legal representatives to federal investigators approximately 6 months later. All of it documented, all of it in the public record. Now, what nobody's covering, buried on page 89 of Thursday's filing, inside Exhibit F, there's a chain of custody notation that should be getting far more attention than the tape itself. The original recording was not stored on a government device, not encrypted, not secured through any official protocol. It was stored on a personal device and then transferred twice before federal prosecutors ever took custody of it. Read that again slowly. A recording of a conversation about a classified military document stored on an unencrypted personal device, transferred twice before federal custody. That single fact changes the shape of this story significantly. Fallout from Thursday's hearing: emergency motions filed by defense counsel that same night. A request for a gag order denied by Friday morning. And a judicial order for in-camera review of 3 additional audio files flagged by prosecutors, all due for submission by next Wednesday. Within 36 hours of that tape being played aloud in that courtroom, the legal landscape of this case shifted visibly. That's just the first document. Subscribe. I'm not done with this. Okay, but look, gotta be fair here. The other side has a real point. Several points, actually, and they deserve to be laid out straight. The defense team's position is that this is a politically motivated evidentiary ambush. The time that I get a recording that surfaced years after the relevant events, delivered through a chain of custody that 2 independent digital forensics experts have already flagged in writing as potentially compromised. And honestly, some of what they're arguing holds up under scrutiny. Their full argument: the recording was obtained from a third party who had a documented financial incentive to cooperate with federal prosecutors. The metadata embedded in the audio file itself shows 2 separate edit timestamps made before the file was delivered to the government. And the individual who physically transferred the recording had previously attempted to sell access to private meetings to a media organization, a negotiation that reached $340,000 before falling through, a fact that the prosecution did not disclose anywhere in the original filing. That is their case. It deserves to be stated clearly. Lead defense attorney, a former assistant U.S. attorney with 19 years of federal criminal practice, put it directly. Authentication is everything in a case like this. A tape with a broken chain of custody proves nothing in a federal court of law. Don't agree with all of it, but that's genuinely not nothing. What the defense has going for them: documented metadata irregularities in the audio file, not disputed, in fact acknowledged by the court-appointed digital forensics reviewer, a cooperating witness with a prior documented history of attempting to monetize private access to high-level meetings for personal financial gain. Even the court-appointed special master, he herself a former federal district court judge with 31 years of evidentiary experience, acknowledged in a written submission the authentication questions raised here are not trivial, and they warrant a complete evidentiary hearing before any probative weight can be assigned to this material. Look, I'm not here to tell you who's right. The prosecution's interpretation of the evidence, supported. The defense's interpretation, also supported in meaningful parts. Both readings can be simultaneously valid. That's exactly what makes this genuinely complicated. What I can tell you with confidence is what the documents actually show. And they show a federal judge who, as of Friday evening, has not dismissed this recording and has in fact ordered it preserved, reviewed, and authenticated on an expedited schedule that gives neither side much time. This didn't come out of nowhere. Backstory, quick version. 14 months ago, the National Archives formally requested the return of 31 specific classified items, each one identified by its individual document control number. 8 weeks after that certified written request was delivered, federal investigators received a written response stating that all requested materials had been returned and fully accounted for. They had not been returned. 6 weeks after that response, a federal grand jury subpoena went out, broader, more specific, targeting communications records, calendar logs, facility access records, and physical movement documentation. Someone said on the record during a formal deposition conducted in late 2024, the exact words were, "There is no recording, there was never a recording, I was never in that room." What happened since then? The recording exists. The person was in that room, and the full deposition transcript from that proceeding is now entered as Exhibit B in Thursday's federal filing. Pattern spanning 4 years. Deny access, claim compliance, deny knowledge, issue a statement, repeat. Every time, got away with it. Until Thursday afternoon at 2:14 p.m. Eastern. Following the trail, hit like. Thursday, 2:14 p.m. Eastern. Here's exactly what happened. Federal Judge Loretta Simmons, presiding over an obstruction-related evidentiary hearing in the District of Columbia, ordered the audio recording played aloud inside the sealed courtroom. No cameras, no press pool admitted. 31 people in that room. According to the sealed hearing transcript that leaked to 3 separate news organizations by Friday evening, Judge Simmons stated before the playback, "The recording speaks for itself." The room went silent during the playback and stayed that way for several seconds after it ended. What followed next moved fast. Defense counsel immediately moved for an emergency recess the moment playback ended, denied on the spot by Judge Simmons. Lead prosecutor filed a supplemental exhibit package within 45 minutes of the playback concluding. Judge Simmons then issued a 72-hour window for full forensic authentication responses from both sides, with no extensions available. 72 hours. That's the active clock right now as of this morning. But here's what every outlet missed while reporting on the tape. Thursday afternoon, in that same courtroom, after the audio playback concluded, Judge Simmons issued a completely separate sealed order. It had nothing to do with the recording. It was about the boxes. Specifically, GPS movement records pulled from a commercial facility management system showing 14 storage containers relocated between 2 facilities between August and November of 2021. Records that were never deleted and never overwritten. Then the next layer. Those GPS timestamps were cross-referenced against sworn deposition testimony from 6 former staff members. The documented discrepancy runs across 23 specific dates. Judge Simmons responded by scheduling a follow-up hearing for June 17th. Not reactive, calculated. The sequencing of her orders tells you exactly where this proceeding is heading. Don't go anywhere. What I show you next changes the picture. What are the experts saying about all of this? Former federal prosecutor Baston, 16 years inside the DOJ's National Security Division, handled classified document prosecutions. When a judge orders a recording played aloud in open evidentiary proceedings rather than quietly admitting it as a written exhibit, that's a deliberate signal. She wants it on the record in a form that survives every appellate layer above her. Plain English. Judge Simmons is building a record that cannot easily be unwound on appeal. Another expert, former chief of the DOJ's Public Integrity Section, now a law professor at Georgetown University Law Center. The chain of custody issue is real. The defense is correct to press it hard, but it is survivable for prosecutors if the tape's content receives independent corroboration from a separate evidentiary source. And the GPS movement logs appear to provide exactly that kind of structural corroboration. The key point there, the tape doesn't need to stand alone. It only needs one additional evidentiary pillar. And those GPS records may be that pillar. Here's what is genuinely striking about where the legal analysis lands. Even a former senior litigation counsel who worked on defense strategy in a related earlier proceeding in this same case concedes publicly, if the GPS timestamps align chronologically with what the audio captures, the authentication challenge becomes extremely difficult to sustain before any serious appellate bench. When people positioned on opposite sides of an active legal fight independently reach the same technical conclusion, you pay attention to that. Professional consensus across the spectrum. The authentication challenge is substantively real, but unlikely to be fatal to the prosecution's case if the GPS records hold under scrutiny. The GPS movement documentation covering 14 boxes across 23 specific dates may represent the more legally durable evidentiary layer of the two. A federal judge who chooses to play a recording aloud in open court rather than admit it quietly as a paper exhibit has already made an internal admissibility assessment. That like button helps. Use it. Why does this reach you personally? Real talk. Why does how this touches actual people's lives? Money. If you have ever signed a federal document, submitted a compliance certification, filed a tax return, or put anything in writing to a government agency, pay attention to what this case is establishing. The current filing proposes up to $2.3 million in civil forfeiture tied specifically to document handling violations. And that is entirely separate from any criminal exposure. The broader precedent being set, when sworn written statements contradict recorded evidence, prosecutors are now moving aggressively, and federal judges are letting them. Your finances are connected to that standard in ways that most people haven't processed yet. Precedent. Next time you are in any legal proceeding, civil, administrative, or criminal, and the other party claims a specific conversation never happened, courts now look for audio, for GPS metadata, for device transfer logs, for facility access records. Quick example. If you are in a business dispute, a landlord-tenant disagreement, a contract negotiation, where someone later denies a meeting took place, the evidentiary framework being built in this courtroom right now gives attorneys representing ordinary people tools that simply did not exist in the same legal form before last Thursday. Who is directly affected? 14 individuals named as unindicted co-conspirators in the underlying obstruction case have had their legal teams filing emergency motions within 48 hours of the playback. They are not waiting for a verdict. They are moving now. Uncomfortable part that nobody wants to say out loud. The recording was made by someone trusted enough to be in that private room. That person then transferred it twice before handing it to federal prosecutors. If you have ever assumed that a private professional meeting was a secure environment, that assumption was tested in open federal court this week, and the recording was admitted. Practical steps that informed people are taking right now, reviewing any sworn written statements made in proximity to private meetings between 2020 and 2023 for potential contradictions. Consulting legal counsel about document preservation obligations if they ever received, handled, or were adjacent to government materials. Asking their attorney one specific question. Does any recorded conversation I am aware of contradict anything I have submitted in writing to a federal or state authority? Knowledge helps. That's the whole point. How did the public response land? It made things worse. Honestly. Friday afternoon, hours after news of the in-court audio playback leaked to the first outlet, a statement issued through a spokesperson called Thursday's proceeding a staged political performance using a doctored recording manufactured for maximum media damage ahead of the midterm cycle. The exact quote distributed publicly, "This tape proves nothing except that our opponents will manufacture and weaponize anything to interfere with the democratic will of 77 million Americans." The reaction was swift. The statement was published publicly, then deleted within 41 minutes, then reposted in an edited version. The edit specifically removed a line that referred to the presiding judge by name. At least 4 prominent federal legal commentators flagged publicly within hours that characterizing an active Article 3 federal court proceeding as a staged political performance is language that can itself attract judicial scrutiny and sanctions review. The prosecution issued an 8-word public response. The court record will speak for itself entirely. Then came Friday night's final move. Defense counsel filed an emergency motion requesting a full stay of all evidentiary proceedings pending the completion of the authentication review. That motion is sitting on Judge Simmons' desk unanswered as of this morning. This is not winding down. What is still genuinely unclear? 1. Who made the original recording and under what legal authority? The filing identifies the recorder only as a cooperating individual and deliberately does not name them anywhere in the public portions. 2. The GPS movement data covers 23 specific dates, but the sealed exhibit list references 31 total dates. 8 dates remain entirely unaccounted for in any public filing, and neither the prosecution nor the defense has addressed that numerical gap publicly. Coming up, Judge Simmons has the full authentication hearing scheduled for June 17th, 11 days from today. Defense must deliver their forensic expert's complete written report by June 10th. That is 4 days from now. A separate but parallel grand jury proceeding has a scheduled witness appearance the week of June 23rd. The date to watch right now is June 17th. Should know significantly more by then. Subscribe, story is moving. I'll cover the update when it drops. Where things stand right now. Saturday, June 6, 2026. A secret audio recording has been played aloud inside a sealed federal courtroom, confirmed by transcript leaks across 3 independent news organizations Friday evening. Judge Simmons has denied every stay motion and every preservation request filed by defense counsel through Friday night. 0 exceptions granted. A GPS movement exhibit covering 14 storage containers across 23 specific dates is now formally admitted and active in the evidentiary record. Scheduled ahead, June 10th, defense forensic authentication report due to the court. June 17th, full evidentiary authentication hearing before Judge Simmons, open to limited press access. Week of June 23rd, grand jury witness appearance in the parallel proceeding, not yet public, the identity of the individual who made the original recording and the content of 3 additional audio files the judge ordered reviewed by this coming Wednesday. The clock is running on all of it simultaneously. That is where we are. A secret audio recording made at a private meeting in the summer of 2021, stored on an unencrypted personal device, transferred twice before federal custody was played aloud in a federal courtroom Thursday afternoon. Surface read, it is a tape story. But the GPS movement records covering 14 boxes across 23 specific dates may be the more consequential evidentiary layer in the long run. And a federal judge who chooses to play a recording out loud rather than admit it quietly as a paper exhibit is making a deliberate and calculated choice about the kind of record she is building for what comes next. I will be watching the June 17th authentication hearing closely. Story is not over. Still developing. Subscribe for the full picture, not just what the headlines give you. When the next documents drop, I will break them down. Talk soon.